Section 280 of the Act provides that an employer must assist WorkCover Queensland by providing all information and access to documents in relation to the claim that WorkCover Queensland reasonably requires. Underneath that, you'll see Section 279 of the Act, which details what documents are relevant to a claim. As you can see from the slide, it seems pretty straightforward. It's information about the circumstances of the event resulting in the injury, the worker's injury, and the worker's prospects of rehabilitation. So, what are relevant documents? Further on in Section 279, there's some guidance on what a relevant document is. Reports and written statements are relevant documents. A written statement doesn't need to be a formal statement or a statutory declaration. It could be a handwritten note, a diary entry, an email, or even a text message. But as you'll see from the definition of relevant documents, there's a reference to other documentary material, which is rather broad. So in determining whether an employer is potentially negligent, we need to have a look at various aspects of how the business operates. And depending upon how the injury occurred, we need particular information about the training given, the worker's induction, and instructions provided to the worker about the task they were doing at the time of the injury, or what systems you had in place to minimise the risk of injury. We will also need to know if any changes were made to the system of work after the injury. A document isn't just a written record and can include photographs, video footage, and voice recordings. You might also get some strange requests from your panel lawyers, as we might ask to come and see how a particular task is undertaken, and we might film that task. It may seem like a very strange request because for you it's just a demonstration of an everyday task, but it actually does really help us and also the claimant's lawyers understand the task, and particularly when you tell us that it isn't possible for an incident to have occurred in the way that the worker claims. I've set out some examples in the slide of some other types of documents which might be relevant to the circumstances of the event giving rise to the injury. The relevance of the incident report or any investigation report is pretty straightforward. The incident report provides a contemporaneous report of the incident and what injury occurred. We can compare this to the description of the incident given in the notice of claim for damages. Sometimes the versions are different. CCTV footage or dashcam footage can be very helpful too. Unfortunately, however, common law claims may not be lodged for some time after the incident has occurred, and the CCTV footage may no longer be available due to storage capacity restrictions in employers' computer systems. We usually find that CCTV footage is retained if there's an event like a robbery or a slip and fall, but very rarely is CCTV footage kept of a worker undertaking a more common task, for example, reaching up high on a shelf or lifting a box of stock. If the worker claims that the injury occurred as a result of a failure by the employer to maintain plant and equipment, maintenance records are important to show how frequently the equipment was serviced and what repairs, or actually, if no repairs had been undertaken. Training records are also very important to demonstrate what training was provided to the worker on how to undertake a task. And this is particularly the case in manual handling tasks. It sometimes doesn't matter how experienced an employee might be, and we'll discuss this in one of the case examples a little later in the webinar. There can be quite intensive examination of the training provided to an employee and the adequacy of that training. And this is, as I said before, of particular importance with claims where the injury has occurred as a result of manual handling. In terms of documents relevant to the injury, many of those will be provided by the claimant, including medical reports. WorkCover will often have obtained some of its own medical evidence during the course of the no-fault statutory claim, but the employer will often have relevant records as well. There may be first aid records, and sometimes the employer will have arranged its own medical examinations in order to assess the worker's fitness for duty. As you can see from the slide, documents relevant to the injury is actually quite broadly interpreted and also includes information about financial loss. So an employer's leave records and wage information for before and after the incident assist us in assessing if the claimant has suffered any financial loss as a result of the injury. In terms of documents relevant to the prospects of rehabilitation, there is sometimes some duplication between documents relevant to the injury and documents relevant to the prospects of rehabilitation, such as first aid records, medical certificates, and medical reports. If WorkCover coordinated the claimant's treatment and rehabilitation during the no-fault stage, your panel lawyer would already have been provided with many documents relevant to the prospects of rehabilitation. I might also just point out here that WorkCover actually has an ongoing obligation to offer claimants assistance with returning to work, which actually extends through into the common law stage. And any documents created then regarding return to work assistance are relevant to the prospects of rehabilitation and need to be disclosed. So one of the key questions that is often asked is, when are these documents to be disclosed? And the employer's duties under sections 279 and 280 don't start until a common law claim is commenced. Any documents that are relevant are required to be disclosed within 21 business days after we receive the documents. On occasion, we have seen requests before there is a common law claim from a claimant's solicitor to the employer, particularly requesting documents about the incident. If one of these letters comes across your desk, it's generally a good indication that a common law claim might soon be delivered. It's a good idea, when such correspondence is received, to consider if there is any video footage that should be saved. If the incident involved any plant or equipment which might be replaced, we recommend taking photographs of the equipment. If the work premises on site is about to undergo a renovation, photographs of the site as it was at the date of incident is also helpful. And also, I guess, if you're an employer who works on a building site, taking photographs at the time of the incident is also very important, because 3 years down the track, the development has been undertaken and the site is so different to what it was at the time of the incident. Just a reminder that there is no obligation to provide documents, as the disclosure obligations do not commence until the common law claim has been started. Depending on the severity of the injury, a claimant may ask their lawyers to assist them in lodging an income protection claim or a claim for total and permanent disability from their superannuation fund. In order to lodge a claim, the claimant's lawyer may need the employer to complete a form or provide some information for the purposes of that claim. It is usually okay for your HR or payroll department to attend to that request directly, but we always ask that you let your panel lawyer or WorkCover know that the correspondence has been received. Sometimes the request will come directly from the income protection or TPD insurer. Again, we recommend that you check with your panel lawyer or WorkCover Queensland, but usually it's okay for HR or payroll to attend to that request. And just that final bullet point there, if you are ever in doubt, check with your panel lawyer or WorkCover Queensland. In summary, what we wanted to give you is some key takeaways. So whilst some common law claims are unexpected and do come out of the blue, many employers have commented to me that they were pretty sure that there would be a common law claim arising from an event. In those instances, we ask that you turn your mind to preserving material which might otherwise be lost, such as CCTV footage and other contemporaneous records. As you can see from our case examples, disclosure is very important, and we don't want to be taken by surprise by a document which turns up many years after the event, such as in that case of Francis. And just a reminder that the obligation is on all parties to disclose, even though it may not feel like it.